Hello, everyone. Thank you for taking time off to be part of this talk today. I'll get straight to it. Okay, so the sequence of my presentation will first touch on, of course, generally what are the limitation periods on certain aspects of actions as contained in the Limitation Act 1953, and then go on to touch on Section 6A, how it alters provisions in relation to time period for limitation in certain actions, namely tortious actions concerning non-personal injury claims. I'll move on to discuss certain exceptions to general limitation period that touches also on aspects of proceedings, and to also explain limitation periods as contained in other statutes, popular provisions which ought to be mindful litigating parties ought to be mindful of. And I will end by discussing what is the procedure in which litigants ought to abide by in using limitation as a defense. Firstly, before going into discussing limitation periods per se, the rationale for limitation periods ought to be understood. And that is this. The presumption is that a right not exercised for a long period was deemed to be non-existent. And this has been held in a Supreme Court case of Credit Corporation Berhad against Fong Tak Sin as early as 1991. Right? The idea is to discourage plaintiffs from sleeping on their actions or claims. Importantly, beyond this, is to have a definite end to litigation insofar as parties are concerned. At the end of the day, the assessment, the consequence of what happens when limitation periods expire, and this is held in Lim Kian against Chu Kun in 1971, held that if expired action is deemed to be time barred, the court does not have discretion to extend the limitation period. Now, it is also very important to understand, appreciate the fact that our courts are very strict when it comes to application of the limitation period, insofar as actions are concerned. It is not open to a party to expect any leniency generally, even if it was 1 day out of time. The matter is time barred, the matter ends there. When we go on to discuss contractual claims, there has been no amendment per se insofar as limitation is concerned. Section 6 sub 1 applies, and that is you have 6 years from the date when the cause of action accrues, to bring an action. And the federal court case of Nasri against Mesa in 1971 has held that the cause of action insofar as contractual claim is concerned accrues on the date of the breach of contract, and time runs from the breach. The only element of subjectivity one could argue insofar as this is concerned is in situations of an anticipatory breach, contractual claim insofar as anticipatory breach is concerned. But then again, even there, the factual premise in which claim in anticipatory breach is concerned is limited, is confined to that. Element of subjectivity will be limited. Move on to discuss tortious claims. Now, pre-amendment, the position was same. Section 6 sub 1 applies, and that is you have 6 years. The issue there was then in relation to actions concerning latent defects. The construction industry had a big conundrum in dealing with situations where their building contract had a situation where latent defects are discovered outside 6 years, but the courts have been harsh in terms of the application, and that the position was 6 years was all they had. So Section 6A essentially now states that you have 3 years from the date of discovery of the cause of action to file an action. 3 years as opposed to 6 years, right? 3 years, and there is a caveat insofar as limitation is concerned, and that is a maximum of 15 years is allowed. So this is expected to limit the harshness insofar as claims pertaining to latent defects are concerned. And then we have actions pertaining to land. Specific provision in relation to the Limitation Act concerning actions pertaining to land is section 9 sub 1. You have 12 years to bring an action. Again, the case of Nasri against Mesa, the court took a broad approach and held that the actions to recover land include actions to enter into possession, delivery possession, declaration of title, a claim for specific performance to execute transfer. There is another case which is interesting to highlight. It's important to highlight, and that is the case of Koperasi Ladang Pekebun-Pekebun Kecil Malaysia against Pihak Berkuasa Kemajuan Pekebun-Pekebun Kecil Perusahaan Getah. The subject matter of the dispute concerned ownership of the subject lands. The court found that the plaintiff's cause of action would have arisen as early as 1970, but even exercising leniency of taking it as late as 1980 was concerned, the plaintiff ought to have commenced its action on or before 1992. But it only commenced its action in 1998. It sought to rely on issues or facts pertaining to the alienation and registration of land in saying that they had matters which are not within their knowledge, and that's why they sought to file the action late. And the court held that they are precluded from doing so, simply because the officers of the defendant and the plaintiff were in fact the same people. The action was eventually dismissed and held to be time barred. And then we go on to deal with action upon any judgments. This essentially relates to enforcement judgments, enforcement of a claim that a party has been successful in court. It is important to note that there is a time bar not only to actions which are commenced initially, but also subsequently insofar as enforcement is concerned. And the statute prescribes a limitation period of 12 years. But for practical purposes, it is important to note that this is limited to 6 years, because beyond 6 years, if you intend to enforce judgment, you'll have to obtain leave of court. And the courts are very strict in assessing the grounds in which you are seeking leave to commence enforcement action after the period of 6 years, obtaining judgment. Normally, the practical problem in relation to enforcement is that litigants have spent considerable time, they have gone through energy drainage, and they realize that there is myriad of factors which require further participation, extensive energy cost. So they choose not to act on a judgment which has been obtained. And this may have would expectedly have adverse consequences beyond 6 years, if at all. We go on to deal with exceptions under the Limitation Act, disability. Now, exceptions, it just says, it discusses, we deal with what are the kinds of disability. There are two, namely, and that is in relation to infants or those who are of unsound mind. Section 24 specifically provides that limitation period starts to around 6 years from the date when such person ceases to be under the disability. An infant ceases to be disabled when he attains the age of 18 or dies, whichever first. Now, of interest to discuss is unsound cases in which unsound mind applies. Unsound mind, the illustration can be seen in the case of Zainun Supian Supea against University Malaya. It's a 2008 case. In 1982, Supian was diagnosed with paranoid schizophrenia. Around 1983, he was dismissed by the defendant from his services. After recovering in 1997, Supian then sued for unlawful dismissal. Although it was more than 10 years after his dismissal, the court held that limitation did not set in, as Supian was incapacitated during the time he had a right to sue. This is another popular exception in so far as limitation is concerned. That I touch specifically on acknowledgement or part payment of debt or liquidated claims. In an action to recover debt or liquidated damages, when the person liable acknowledges or makes a part payment, the right of action accrues afresh. And this is to be found in section 26. The case a case on point will be Tenaga Nasional Berhad against Kamar Stones and Rian Berhad. The federal court held that there was a clear, unequivocal acknowledgement by the respondent that there was a subsisting debt in a letter dated September 2003. Now, in the circumstances, the right of action of the appellant for the shortfall of the period prior to 1999, in which the limitation would have otherwise set in, was deemed to have accrued only on 2003. So that is a case on point. And insofar as acknowledgement is concerned, yes, the provision requires the acknowledgement to be in writing, but pursuant to the Electronic Commerce Act 2006, and as held and acknowledged in the case of Yam Kong Sen and Yi Weng Kai, a 2014 case, an acknowledgement, even an SMS, could be held to be an acknowledgement valid and enforceable. And we go on to discuss the issue of fraud or mistake. Now, the natural misconception insofar as fraud or mistake is that the moment a person raises the issue of fraud or mistake, then there is no issue of limitation. That is not the case. Section 29 of the Limitation Act only allows for a postponement for the limitation period, and it will not begin to run until the plaintiff has discovered the fraud or mistake, or could have reasonably discovered, could have discovered it with reasonable diligence. So there would be an assessment, there is a subjective assessment that the court will undertake insofar as ascertaining whether steps were taken, or you could have been reasonably expected to have known your circumstances which allow and afford a cause of action, despite there being fraud. Section 6A shall not apply to any action in relation to fraud. So that is preserved. The new amendments do not extend to to Section 29. Okay, outside the Limitation Act, we have the very, very popular Public Authorities Protection Act. It predates our independence, but it is held on and used by the courts in a very strict manner, right? There is only a 3-year period in which a party can commence an action against a public authority, and the act complained of must be done in pursuance of the execution of any written law or public duty or statutory authority. And the strictness in terms of the 36-month period can be seen in the case of Selvaraju Ponea and Suruhan Jaya Perkhidmatan Awam Malaysia. It's a 2007 federal court case where the court applied the provisions strictly. Aside from the Public Authorities Act, there is also the Railways Act 1991, which relies or says that the provisions insofar as limitation as contained in the Public Authorities Act would apply against Kereta Api Tanah Melayu Berhad as well. And that the case on point will be S. Veerasingham, and it's also the 3-year period. Okay, what happens when an action is deemed to be time barred? What will the allowance be for a party who is seeking to fend off the issue of limitation? Firstly, the defense of limitation would require you to raise it in your pleadings. You will have to plead the matter sufficiently, and what you are expected to do is then apply summarily to dispose the action by way of a notice of application to strike out the matter. There have been, over time, conflicting decisions as to whether there is a necessity to plead or not. But generally, the position is that you ought to plead it and go by way of a striking out application under Order 18, Rule 19. And there the cases have consistently struck out the matter. It's an absolute defense, it's a whole defense, and the matter would end there. Okay. about what I have to present today. Sarah?
Thank you. Thank you, Rishi. Okay, once you stop sharing your screen, I'll put mine.
What I will do is essentially before Rishi comes, as you all have noticed, Rishi has given us a bird's-eye view of the limitation provisions and what is relevant. As you know, wrongdoers may be in control of companies. In our case, as you all will notice, the 1MDB case is one good illustration of how limitation period can be really difficult, because during the period when there were a lot of wrong committed to 1MDB, the company was in the hands of the wrongdoers. That's what 1MDB states. What happens then when limitation period expires? Or is the limitation period, does the limitation period expire? And that is not only 1MDB, we have got many companies where majority shareholders controlling the company do things that are not in accordance with the provisions of the company law or according to the fiduciary duties, but you are not in a position to take control of the company. You only take control of the company well after the time. What are all that? We will discuss all that during question time. Now we will listen to Saravana and he will guide us on the various provisions under the Income Tax Act.
Thank you, Dr. Naban. I'm also going to go straight to the issue. It's a Friday afternoon, so I'm sure we got other exciting things to do as well. So I will start with a case law, a case that Dr. Naban and I did not too long ago, the case of InfraQuest, which is one of the best cases when it comes to examining what is time bar. We lost at the Special Commissioners, but we won the case at the High Court and Court of Appeal. And taxpayer was in the business of providing telecommunication tower services, and revenue assessed the taxpayer for a number of years from the year 2003 to 2008. We argued that 2003 and 2004 are time-barred years. And of course, as we all know, time bar can be raised under the Income Tax Act, although there is a 5-year general limitation under Section 91, subsection 1, and a 7-year limitation for transfer pricing. But for income tax purposes, the Inland Revenue Board can go beyond the time bar period in 3 circumstances: where there is fraud, where there is willful default, or where there is negligence by the taxpayer. And in this case, the Inland Revenue Board, their favorite flavor is negligence, and they say the taxpayer committed negligence, and therefore we are entitled to raise time-barred assessments. And for those friends who are listening to this session today, who are familiar with tax audit and investigation, revenue is now very fond of raising time-barred assessments now. So when we argued this case, our position was the word negligence is not defined in the Act, and therefore we now got to decide what is the meaning of the word negligence. It is not what the IRB thinks is negligence, but depending on what the law has stated. The law says the test is what a reasonable person would do or would not do. That's it. The reasonable man out there, what will he do or will not do? And if you look at the interpretation, it says the revenue can raise the assessments at any time, but revenue must be subjected to this burden to establish that there was negligence in this case. The burden is to be established by the IRB. It is not for the taxpayer to go and prove that you're not negligent, right? It is for the IRB to prove you are negligent. And similarly, if IRB claims that you have committed fraud or willful default, revenue also must establish that. I'm of the view you cannot be guilty of fraud, willful default, or negligence at the same time. Whilst fraud and willful default has the criminal element or the mens rea element, but for negligence, the test is completely different. And our courts have ruled that for willful default and fraud, the IRB's burden is the criminal burden beyond a reasonable doubt, whilst for negligence, it is a civil burden. IRB got to prove the case on balance of probabilities. Hence why negligence is the preferred what you call reason for the IRB in raising time barred assessments. Yeah. So we then said in this case, upon establishing all our evidence, the court said that the revenue failed to establish negligence. So the court said, upon critical analysis of the evidence available, both oral and documentary, the court was satisfied that the taxpayer had led evidence to prove otherwise, right? So if you are wondering what amounts to a position where you say that you're not negligent, how do you establish that? And for that, if you look at the facts of infra-quest, if I may just share with you, what is this evidence orally and documentary available? There are altogether 9 points that we put forward, which the judge accepted. And because it's too lengthy, I didn't reduce them into slides. Let me share this with you, yeah? Number 1, the taxpayer at all times took professional advice from a tax agent. Number 2, taxpayer provided cooperation to the IRB during the audit by giving all the documents requested. Number 3, taxpayer made full and frank disclosure of the tax treatment in the tax computation. Number 4, the details of the capital allowance claims were stated and itemized in the tax computation. Tax returns for the years 2003 and 2004 were filed within time. The IRB gave no reason at all to justify the raising of time bar assessment, neither did they give taxpayer the opportunity to explain otherwise. No attempt was done by the taxpayer to evade or avoid tax. The taxpayer only learned the time bar reason of negligence during the course of the hearing at the special commissioners. There was evidence to show the taxpayer was never investigated or reprimanded by the IRB in the past. And taxpayer had always ensured his taxes were paid in good time. On that basis, the court said, what the taxpayer has conducted himself here is so diligently of what the law expects of a reasonable person. And the taxpayer did not omit to do something that a reasonable person would do. So it is very, very important that we establish sufficient evidence, both orally and documentary evidence, to establish that there was no elements of negligence when a taxpayer conducted his tax affairs and in the way they conducted themselves during the tax audit in this case. Further, the learned High Court judge also took into account that the IRB officers himself during cross-examination agreed with the question by Dr. Naban that the taxpayer was not negligent. So the court then said, applying the definition of negligence, the court found no failure to give any written or whatsoever as required by the law in this case, and therefore the taxpayer cannot be said to have acted negligently. Then the other argument that the IRB raised, which the special commissioners agreed, but the High Court disagreed, was that is negligence because the taxpayer was wrongly claiming capital allowance. You know, the court said, the special commissioners and the IRB said, oh, the item is not plant, therefore you can't claim capital allowance. The court said, the mere fact you went and claim, the mere fact you go and claim that that is capital allowance, court said that alone cannot make you a negligent person. Yeah, the court said negligence cannot take place just because you take a different view from another person. And this is a very important case because the judge in this case went and considered an old Malaysian case called Ng Sun Chun in a civil recovery case where the IRB was suing the taxpayer for 2.2 million ringgit, and the taxpayer argued that the years 53 to 59 were time barred, and therefore IRB cannot raise any time barred assessment. And that is where the learned judge said when a plea for time bar is made, then no claim for the enforcement can be entertained without there being an opportunity for the taxpayer to be able to have the opportunity to establish his case, i.e., you cannot stop the taxpayer from raising the defense that the assessment in question is time barred. So this is of good importance when the revenue sues you for a non-payment of taxes and the assessments are time barred. That is a triable issue, and the Inland Revenue Board has the burden to establish the taxpayer has acted negligently if they want to raise assessment. So we can see how the law operates in income tax matters, where time-barred assessments are very common, including in transfer pricing matters as well. For friends who have joined our sessions in the past, you would have heard about the case of MM, the first transfer pricing case that we handled, where there was also time-barred assessment. And one of the arguments that the IRB raised was that Section 140 of the Income Tax Act, and very clearly, this can amount to no basis to raise time-barred assessment. But the court ruled Section 140 also apply also subject to time bar. Revenue cannot raise assessments in this kind of time-barred situation. So time bar applies to the entirety of the conduct of the IRB raising assessment. So you'll be wondering, why is IRB still raising time-barred assessment? Simply because, in my view, I think it's because you pay first, talk later. Because although it is time-barred, you still got to pay your taxes, lodge an appeal to the special commissioners, and have the case heard there. That could be the reason why they're not stopped or not perturbed in raising time-barred assessments. So unless a strong intervention comes from Parliament to amend the law, whereby maybe my suggestion is that where there is time-barred assessment, then until the assessment is proved, revenue shouldn't be entitled to collect that taxes. It is not fair to the taxpayer because it's already beyond the limitation period. But this is for something for legislature to consider in the years to come, or in the next months to come. Anyway, budget is around the corner. So this is what I would like to share about tax. So to sum up, the tax assessments, revenue, if they want to raise assessment beyond 5 years for normal taxes or 7 years for transfer pricing, they got to establish either that is fraud, willful default, or negligence. There is no excuse for IRB to raise time-barred assessment just because it is a tax avoidance case or a tax investigation case. So on that, I see a lot of questions are coming in. Perhaps I will end here and answer questions after this.